So in case you forgot, convicted felon President Donald Trump was found guilty by a jury of his peers on 34 felony counts of falsification of business records, found liable for defamation, civil fraud, and sexual abuse. And had he not successfully returned to the White House, would still be facing several criminal cases. But now, as president again, Trump has launched a revenge tour, weaponizing America's judicial system for retribution and targeting his perceived enemies with executive orders. But there are some in the system that aren't going down without a fight. Late yesterday, in response to two separate lawsuits brought by Jenner and Block and Wilmer Hale, two different federal judges appointed by George W. Bush temporarily blocked the Trump administration from enforcing parts of the executive orders targeting those law firms, with one judge saying, quote, "There is no doubt this retaliatory action chills speech and legal advocacy, and that is qualified as a constitutional harm." Joining me now is Rachel Cohen, attorney and a former associate who resigned from Skadden Arps in protest of the way that the firm handled those threats made by Donald Trump. Rachel, it is an honor to have you on my show. The timing is interesting, though, isn't it? That just yesterday, the news was released that your former law firm, Skadden Arps, did, and I will use my own phrase, capitulate in advance to Donald Trump. Skadden had not been facing an executive order per se, but decided that it wanted to negotiate what Trump called a settlement, which has its own meaning, doesn't it, legally. I wanted to get your thoughts about the fact that the law firm you used to work at for almost 3 years has now bent the knee.
Thanks so much for having me, Katie, and the honor is all mine. It is fascinating timing, as you stated, given that Skadden decided to comply in advance. There's no need for you to qualify that capitulation is your term, because it's mine as well. Though I don't know if you can capitulate to a threat that hasn't actually been made yet. I am disgusted, and I will say another former Skadden associate actually put in public notice yesterday in response to what she called, I believe she used the word craven, which I think is exactly accurate. I'm both disappointed by this response and also befuddled, because we have, or I'm still technically on Skadden's payroll for another week, so I will say we have a reputation for being really outstanding M&A attorneys, that we're good at negotiating. And the first rule of negotiation is that you do not negotiate against yourself. So I am at a loss as to why Skadden decided to hedge its bets on not only taking such a public action so far in advance before the Trump administration kind of turned its threatening eye upon them, and also to come out with such a bad deal. They've promised $100 million in legal services to the Trump administration. It's absurd.
Yeah, the original amount from Paul Weiss was $40 million. Now with Skadden, it's $100 million. I reasonably anticipate the next law firm, big law firm that capitulates, is going to be more. But you know what upsets me a lot, Rachel, about this is the fact that the executive partner at Skadden Arps agreed to this language that there's illegal DEI that's going on at Skadden, which, you know, bothers me. And in the statement, the email that he sent out firm-wide, he ended the email saying, "With this resolution, I'm confident we're going to go forward with resilience, strength, and integrity." Integrity is a funny word to be used there. Talk about why this is not profits over people, because that's what it feels like to me. It's profits over people.
I don't know that I can talk about why it's profits over, or why it's not profits over people, because I agree with you. And I think it's worth noting here that I put my resignation in a little over a week ago, publicly requesting that the firm commit to not capitulating to the Trump administration, both because we were hearing some whispers about firms other than Paul Weiss kind of going to the White House and talking to the president, and also because the kind of non-answers that we were getting from firm administration when we were asking questions as associates about how we planned to proceed here felt extremely profits over people, though I would argue that this is, in the long run, quite bad for Skadden's business, and I'll come back to that in a second. But also, we were the subject of an EEOC demand letter that was sent to Skadden Arps as well as 19 other law firms a couple of weeks ago. There's no enforceable mechanism behind these EEOC demand letters. And in fact, a lot of former EEOC commissioners are pointing out that not only are they unenforceable, but they were likely illegally delivered. And so these letters request a lot of personal information, and it's clearly targeted at intimidating my colleagues of color. because it asks for things like race and it focuses on fellowship programs and diversity programs that were historically open to people from diverse backgrounds. And so this kind of reference to illegal DEI is vile because number one, that's not a real thing, this notion of illegal DEI. But number two, partnerships remain, I believe the stats are 88% white and 75% male. And so to have Jeremy London, a white man, who replaced another white man as our executive partner, talking about illegal DEI when the advantages that have been had in this industry over and over and over again are those of white men like Jeremy, is particularly repulsive and intimidating to non-white people. And so coming back to the idea of profits over people, I think that that's very much what's happening, but I also think that it's going to be bad for profits because we've seen the reaction industry-wide and among clients to Wilmer, Jenner and Block, and other firms that have decided. Perkins Coie came out swinging from the get-go, which is very admirable. We've seen the kind of overwhelming support, not just from others in the industry, but also from clients, because you want to know that firms that you are paying upwards of $3,000 an hour for at times are good at standing up for you. And if they can't stand up for themselves, how on earth could you expect that of them on your behalf?
You know, Rachel, I mentioned at the beginning of your interview, you were at Skadden for 3 years. Working at a place like Skadden, for those that are tuning in that maybe didn't go to law school and aren't in the legal profession, it is a brass ring. It is very much a gold standard. But you raised such a good point, which is it is so hard to break into big law when you are a woman and a minority. I'll use myself as an example, right? It's even harder to ascend within big law, to be able to become an equity partner, to get a seat at the table, to be able to have a voice in what is happening. And so how important is it then for people to look at WilmerHale, Perkins Coie, Jenner and Block, who, by the way, are getting temporary restraining orders in protection of them against the Trump administration? How important is it for people to look at them and say, you're right, these are the law firms that we want to do work with because they're the ones that are going to stand up and defend us and our interests, and DEI is going to be protected there?
I think it is one of the most urgent moments for clients, for firms, for the industry of our lifetimes, because the impacts on diverse associates and employees at these firms is heartbreaking and horrible. But I really do think that, believe it or not, that the stakes are even higher because, as you kind of framed in the intro, this is an all-out intimidation campaign being waged by the Trump administration to try to see if the legal industry will put up with what is going on in his administration right now, which I would argue is very much a coup. An attempt to undermine the rule of law, to have unelected advisors playing huge roles in government, doing things that are illegal constantly, doing things that could be legally done in an intentionally illegal way, like the delivery of these EEOC demand letters, to see if people will stand up to him. Because if law firms aren't willing to stand up to him to protect themselves and their employees, I think the Trump administration is correctly reading that they certainly will not be likely to stand up to him when he is illegally deporting people, as we also see him doing. I'm going on the news and talking a lot about these firms because that's what I have direct experience in. But I think that it's very important that we remember that these kind of attacks on the institutions are done not really to attack the institution, but to make sure that the firms and the other institutions will not stand up for due process rights more broadly. It's the same reason he attacked Columbia, to see if they would let him storm their campus and grab people who are legally here in this country and deport them over free speech rights. And so it matters on the micro level at these large firms, which are a very insular part of a very insular industry. But it also is unbelievably urgent on a macro countrywide level in terms of whether or not we descend into all-out authoritarianism.